So hi everyone. In the last class, we have discussed about the divorced person may when get married again, and we have also discussed the legitimacy of the children in the void and voidable marriages. Okay. So when we are discussing about the divorced person may when marry again, in this session, in this class, we have discussed that when there is no further chances of appeal in any particular case, in that case the divorced persons may remarry again. Okay, so just for the example, we have already discussed upon that. Like for example, if there is a case of the divorce, it might be the mutual divorce or it might be the divorce by the application of the any party, whatever it is. So after granting of the divorce, if it feels like any of the specific party is not happy with the decision of the another party. For example, I am a party and I am not happy with the decision of the court. And the court has granted me the divorce, but I don't want the divorce from my husband. And I am not agreeing with the decision of the court, and I feel like there is certain injustice is happening to me, then I have my whole rights to go to the higher court against the decision of the district court. Because usually the family court is sitting and based on the district court itself. Okay, district and session court, it usually deals with the matters of the divorce, like the court of the chief judicial magistrate or the court of the judicial magistrate first class, judicial magistrate second class. They don't deal with the divorce or marriage petitions. The divorce cases or the marriage cases that is specifically been dealt by the sessions judge or the district court or the district and sessions judge, the court that usually handles these these petitions of the divorce. Okay, so when we're talking about section 15, we have discussed that when there is the petition of the divorce and the court has granted to divorce to the both of the parties or any of the specific parties on any ground mentioned above under the provision of the divorce or judicial separation or restitution of the conjugal rights, whatever it is. So after the granting of the divorce, if any party is not happy with the decision of the court, the party can go to the higher court. That means after the district court, what is the higher court? The higher court is the high court itself. So if the party is going to the high court and after being dissatisfied with the decision of the high court, the party is going to the Supreme Court. The opponent party, okay, that means the person who has on whose side the decree has been passed, that person is not able to remarry until the matter is fully sorted out. Okay, for example, if the person is moving to the high court, then the person has to wait till the matter is over at the high court itself. है ना? They both have to wait sorted out. So when we're talking about the divorced person may marry again. Okay. So this is about that when the divorced person can get married again and again. So the first thing we have discussed, as I told you, like after the completion of the process of the appeal and all, the persons can get married again. The second point, after the grant of the divorce, the persons, if they see that there is no further appeal, there is the party had the both of the party they have granted the divorce and they are happy with the decision. They don't want to argue to the higher court. They don't want to get the issues of the courts and the laws and the rules and regulations. They want peace. That is why what they are doing, and they are telling that yes, this is the matter we wanted to sort it out, and just let's finish it. We don't want further arguments and we don't want the matter to proceed further. है ना? So in that specific circumstances, we need to know that in those cases also the person can remarry because there is no further chances of the appeal of the particular case. Hela? Got it? So in the third circumstances, when both of the parties are or both of the lawful parties are in a condition that the right to appeal has been expired or been rejected by the court of law. Expired means, for example, there is the duration of the time period of 1 month to appeal against the decision of the lower court. But after the decision of the lower court, it has been more than 1 month, the parties has not put the appeal against it. Okay. So here, when there is no further appeal further against the decree of the divorce, and the time period or the duration to appeal has been already expired, and there is the full on probability that there is no further appeal is going to be issued. In that case also the persons can remarry again. Okay, got it? So under section 16, it speaks about the legitimacy of the children of void and voidable marriages. Okay. So under section 16, we are talking about the legitimacy of the children in the void and voidable marriages. What does it mean? We are talking about that when the marriage is called as a voidable Hindu marriage or void marriage, then what is the and who will be considered as their parents from that particular marriage? Okay. So this is what section 16 discussed in detail. Okay. Under section 11, we have discussed the marriage is called when the marriage is null and void in nature. This marriage is called as the void Hindu marriage. Okay. So when we are talking about the void Hindu marriage, any child of such marriage who would have been legitimate if the marriage had been valid shall be legitimate whether such child is born before or after the commencement of the marriage laws. Okay. And whether or not the marriage is held to be void otherwise than a petition under this act. Okay. So what does it mean? It means that when the marriage is called as the void marriage, and we have understood the terms and conditions of declaring a marriage void. What are those terms and conditions? The first terms and condition we have discussed that when the parties to the marriage who are getting married, according to the first condition, they must not be married before at the time of the marriage. Okay. So शादी करने से पहले उनका दूसरा कोई पति या पत्नी नहीं रहना चाहिए. They would be completely single, divorced, or if the husband and wife was there, they must have died. Okay. So there should not be the presence of any specific husband or wife at the time of the marriage or during the time of the marriage. So this is the first priority. The second thing we have discussed to declare a marriage void marriage, that about the rituals of the marriage. According to Hindu Marriage Act, we have understood that we give certain relationships some certain specific names. Just like we are talking about how to make it understand. Okay, let's understand it in this way. Like you are my sister's mother, or you are my no, you are my mother's sister. Okay, you are my mother's sister. That means अगर हम हिंदी में बोले तो आप मेरा मौसी लगते हैं. क्या मैं अपनी मौसी से शादी कर सकती हूँ? द आंसर इज नो. अपने जो ब्लड रिलेटिव्स होते हैं, जिसको हम अपना ब्लड रिलेटिव बोल सकते हैं, क्लोज रिलेटिव बोल सकते हैं, एंड दैट ऑल्सो कम्स अंडर ए सैप इन द रिलेशनशिप अंडर द हिंदू मैरिज एक्ट. तो अगर कोई सैप इन द रिलेशनशिप का बात आता है तो हमको इस बात का अंदाजा लगाना चाहिए कि सैप इन द रिलेशनशिप में इन बिटवीन द ओन ब्लड रिलेशन द मैरिज इज not possible as so far. So when the marriage is void and null under section 11, then any child of such marriage who would have been legitimate if the marriage had been valid. अगर शादी ना void declare हो जाता है due to the discovery of the fact that the husband is important, or the husband is having an extramarital affairs, और हम ऐसा मान लेते हैं कि the husband is suffering from any venereal disease. Okay, so these things declares the marriage as a voidable. void के बाद हमने क्या डिस्कस किया था? मान लो कि the husband has been married before this marriage, मतलब एक लड़की शादी करने से पहले उसका पहले भी अफेयर्स था. द पर्सन हैज ऑलरेडी मैरिड बिफोर. ओके, if the person is already a married person, then the second marriage is called as the void marriage. second marriage को दूसरा void marriage माना जाएगा, क्योंकि उसी का पहली जो वाली थी, पहली पत्नी जो है, उसी को ही उसका पत्नी माना जाएगा. सेकेंड वाली बंदी कितना भी अच्छी ना हो, उसको उसका पत्नी नहीं माना जाएगा, बिकॉज दिस इज द अगेंस्ट द लॉ. और दूसरा सिचुएशन क्या हमने डिस्कस किया था कि अगर मैं अपने भाई से ही शादी कर लूं, अपने रिश्तेदारों में शादी कर लूं, विल इट लुक गुड? इज इट Is it supporting to our rules and regulations and policy? The answer is no, because this is strongly against our policy कि आप अपना blood relation पे शादी करो करके. एंड अगर आप ऐसा करते भी हो ना, then it is void according to the court of law. अगर आप उसी के बेसिस पे आके मेरे को कोर्ट पे मांगोगे कि मेरे को दलील चाहिए, या फिर अगर आप उस चीज के बेसिस पे you are coming to me and you are telling me that declare this legitimacy of the child as the invalid, then the your request will be rejected and the child will be called as the valid legitimate child. मतलब मैं ये बोलना चाह रही थी, अगर मान लो कि आप एक इंसान से शादी कर लिए, आपको नहीं पता कि शादी से पहले उसका कोई दूसरा शादी भी हो चुका है करके, आपको इस बात का अंदाजा नहीं है. आपने क्या किया? शादी कर ली. शादी करने के बाद आप कंसीव हो जाते हैं, आपका बच्चा होने वाला होता है. बच्चा होने से 3-4 महीने से पहले आपको पता चलता है कि ऐसा ऐसा सिचुएशन है, उस इंसान का दूसरा कोई बीवी भी है. तभी आप क्या करोगे? यू आर द थर्ड पर्सन इन बिटवीन दोज हस्बैंड एंड वाइफ. उनका पर्सनल लाइफ में, उनका पर्सनल स्पेस पे यू आर द स्ट्रेंजर ओवर देयर. सो आपका कोई हक नहीं है उधर उनके लाइफ में एंट्री करने का. एंड टू आस्क फॉर द डिवोर्स, दैट इज टोटली इलॉजिकल. यहाँ पे आप ये चीज नहीं कर सकते. गॉट इट? एंड द सेकेंड पॉइंट, ओके, उस रिलेशन से अगर मान लो 3 महीना रिश्ता रखने के बाद, 3 महीना उसके साथ साथ रहने के बाद पता चलता है कि उसका एक बेबी, उसका एक मतलब दूसरा भी, पहले भी वो शादी कर चुका है एंड दूसरा और भी एक बीवी बच्चे हैं, वो दूर रहते हैं करके, तो उस सिचुएशन पे आप क्या करोगे? उस सिचुएशन पे द आंसर इज वेरी सिंपल, दैट यू आर गोइंग टू स्टे विद दैट पर्सन, ऑब्वियसली, क्योंकि आपका बच्चा होने वाला है. एंड अगर आप डिसाइड करते हो कि आपको उस इंसान से छुटकारा चाहिए, देन द मेजर थिंग यू नीड टू डू दैट द मेंटेनेंस. ओके, क्योंकि आपका जो बच्चा होने वाला है वो किसका बच्चा है? उस बंदा का बच्चा है. भले ही शादी को भयड माना जाएगा, भले ही शादी को वैलिड लेजिटिमेट नहीं माना जाएगा, भले ही आपकी और आपका जो पति है उसको कानूनी तरीके से आप अपना पति बता नहीं सकते हैं, बट देर आर सो मेनी सर्टन अदर थिंग्स which are coming forward कि even if you are not accepting the marriage, even if you are declaring the marriage as the void or voidable marriage, but the child produced on behalf of that void marriage is considered as a legitimate Hindu child itself. Okay, got it? So this was all about the voidable marriage, and we discussed that the child produced on behalf of the void marriage is called the legitimate child itself. उस बच्चे को हम legitimate child ही मानेंगे. दूसरा हमने पढ़ रहे थे अबाउट द वॉइडेबल मैरिज. वॉइडेबल मैरिज को तो काफी कंडीशंस हमने ऑलरेडी डिस्कस करके रख चुके हैं, जैसे कि द इम्पोर्टेंस ऑफ द पार्टीज, और देयर आर सो मेनी रीजंस to declare the marriage as the voidable marriage, because for example the person has married before their age, like शादी का उम्र कितना है, 18 साल है और 21 साल है, मान लो उसी से बहुत पहले ही 18 साल पहले ही पति पत्नी दोनों का शादी हो चुका है, एंड आफ्टर ए सर्टन एजिंग पीरियड उनको ये चीज रियलाइज होता है कि जो कुछ भी हुआ था वो गलत हुआ था उनके साथ, तो उनको ये शादी करनी नहीं चाहिए थी, एंड दे आर रियलाइजिंग दिस एंड दे वांट टू प्रोसीड फर्दर इन देयर लाइफ, and that is why they don't want to continue as the husband and wife, and they are filing a petition to declare the marriage as void. Okay, so here both of the parties are unable to continue the married life. Both of the parties are unable to continue the so in that case the marriage might be declared as the void marriage, but the child produced on behalf of that specific marriage will be considered as a legitimate child itself. So this is the speciality of section 16 of the Hindu Marriage Act. What is the speciality? The speciality is, even if the marriage is a void Hindu marriage or the marriage is a voidable Hindu marriage, it does not matter. ये मैटर नहीं करता कि जो मैरिज है वो भॉइड हिंदू मैरिज है या वो भॉइडेबल हिंदू मैरिज है, बट ये मैटर करता है कि इवन इफ द मैरिज इज नॉट कंसिडर्ड एज ए वैलिड मैरिज, इवन इफ ये जो शादी है ना, इस शादी को हम वैलिड मैरिज नहीं बोल रहे हैं, but the child produced on behalf of that specific marriage is called as a legitimate child of their father and mother. उस शादी से जो बच्चा पैदा होता है, द चाइल्ड प्रोड्यूस्ड ऑन बिहाफ ऑफ दैट मैरिज इज कॉल्ड एज ए लेजिटिमेट चाइल्ड. उस चाइल्ड को लेजिटिमेट माना जाएगा. गॉट इट? नेक्स्ट पॉइंट. Then the section 17 it speaks about the punishment of the bigamy. Okay, so when we are talking about the punishment of the bigamy, then any marriage between two Hindus solemnized after the commencement of this act and is void if the death of such marriage either party had a husband or wife living at the time at the provisions of section 494 and 495 of Indian Penal Code shall apply accordingly. Okay, so what does it mean? An application between two Hindus solemnized before the commencement of the act in contravention of the conditions specified in clause 3, 4 and 5 of section 5 will be punishable. Okay. Let's have just a look section 3, 4, 5 of clause 5. What does it speaks about? Okay. तो यहाँ पे जो मेंशन किया हुआ है ना, सेक्शन क्लास 3, 4, 5 ऑफ द क्लास सब क्लास सेक्शन 3 अब सब सेक्शन 5. सो यहाँ पे सेक्शन क्लास 3, 4, 5 of section 5 it speaks about the conditions where the parties has already married or where the parties were below 18 years of the old, or where the most importantly the parties were married before. Okay, for example, you and me are entering into a relationship and we have decided to marry. Okay, and what is happening that when we are talking about the marriage between we both, okay, it is happening that court to which the petition shall be presented. It is about the clause 3, 4 and 5 of the section 5. Clause 3 speaks about the clause 3 of the section 5. It speaks that if the parties has got married before their reaching of specific age. For example, for the girls, the specific age to get married is 18 plus, and for the boys, it is 21 plus. So if the boy and girl they have married before their specific age against the wish of their family, they want to break the marriage. That is also called as a void Hindu marriage. Okay, got it? Section 19, it speaks about punishment for conviction of certain other conditions of the Hindu. है ना? If the clause is clause 3, 4 and 5, which speaks about the blood relation and sapping the relationship, and most importantly, it is going to clause 3 speaks about if the parties were married before the specific marriage. मतलब ये शादी होने से पहले ना उन लोगों ने ऑलरेडी कहीं शादीशुदा हो, then in that case this is the implementation of section 5 ka clause 3, 4 and 5. And in this case we know that the contravention of the conditions specified in clause 3 of section 5 with religious imprisonment which may extend to 2 years or fine or which may extend to 1 lakh rupees or both. Okay, तो यहाँ पे जो imprisonment का period है ना वो 2 लाख से ज्यादा extend कर सकता है और it might be extend to 20 lakh of the rupees. Got it? And the next point we have discussed about the punishment of the bigamy. Okay, so when we're talking about the punishment of the bigamy, we know that any marriage has two Hindus solemnized after the commencement of this act is void if the date of such marriage either party and has husband and wife at the living, the provisions of section 394 and 395 of the IPC shall apply accordingly. Okay, got it? Then आपका आता है section 18. It speaks about the punishment for contravention of certain other conditions of the Hindu marriage. So what are the punishment for the contravention? Then it speaks about that section, the clause 3, 4 and 5 of the section 5. If it is the terms and conditions of the Hindu marriage, then the rigorous imprisonment which may extend to 2 years or within fine which may be extended to 1 lakh rupees or both. Okay. So what does it mean? It means if the persons has got married before or if the persons are happiness of the relationship, those things declares a marriage as a void Hindu marriage. Okay. But we know that in the case of contravention of the conditions specified in clause 4 and 5, the sample the simple imprisonment which may extend to 1 month with fine which may extend to 1,000 rupees or both. Okay, so under the clause 3, 4, 5 it was fine, but after that we are talking about the clause 4 and 5. It is about the restriction in the sapping the relationship. Okay, with imprisonment which may extend to 1 month or fine which may send to 1,000 rupees. Okay, got it? Then the next point, it speaks about the punishment for the bigamy. Punishment in favor of the person, certain conditions of the Hindu marriage that we discussed. Like we have discussed, if it is lacking the section 5, then the punishment is going to be the fine. Okay, and the imprisonment which may extend to 2 years or with fine which may extend to 1 lakh of the rupees or both. The fine of the 1 lakh rupees or 2 years of the imprisonment. These things we have discussed. Okay. Next, court to which the petition shall be presented. So we need to know what is the court where the petition should be presented in a well manner. Okay. Then coming forward, we all know that under section 19, every petition under this act shall be presented to the district court within the local limits of whose ordinary original civil jurisdiction. Okay, that means we are talking about that when every person has presented under this act shall state a discretionary as the name of the permits the facts on which the claim and the relief is found, and except the petition under section 11, it shall also that there is no collusion between the parties between the two. Okay, ये गया आपका. Okay, then आपका आता है section 19. Okay, section 19 speaks about court to which the person shall be presented. It speaks about the specific court to which the person shall be presented. Okay, and it depends upon the circumstances and the conditions itself. Okay, then what does it mean? Every petitioner under this act shall be presented to the district court within the local kinds of with some ordinary engineering original civil jurisdiction. Okay, so what does it mean? Every petition under this act shall be presented to the district court within the local limits of which originally civil jurisdiction. Okay, ओरिजिनल सिविल जुरिस्डिक्शन से ही अगर कोर्ट में किसी भी तरह का केस आता है, then it is the duty of the court to transfer the language of the judgment according to the need of the clients. Okay, ये गया आपका सीधी बात. आगे बढ़ते हैं. The parties to the marriage has resided in Guha. Yes, got it. So in that particular case, what will happen? That so in that particular case, the court will entertain the petition, and the court will give certain time to both the parties to reach up to a specific decision. Okay, so what does the section 19 speaks? Every petition under this act shall be presented to the district court within the local limits whose ordinary original jurisdiction the marriage was solemnized. First point. The second point, the respondent at the time of the present of the petition resides. Point number 3, the parties to the marriage last recorded together. Then number 4, in case of the wife is a petitioner, where she is residing at the date of the presentation of the petition, or the petitioner residing at the time of the presentation of the petition, in a case where the respondent is at that time residing outside the territories to which the act extends. Okay, and the husband is not being heard of alive more than 7 years, usually from whom he would have naturally have heard of him if he were alive. Okay, तो ये जो सारा कंडीशंस हमने पढ़ा कि कोर्ट टू हुइच द पिटिशन शैल बी प्रेजेंटेड अंडर सेक्शन 19, कौन सा कोर्ट पे आप अपना पिटिशन फाइल कर सकते हो, इन हुइच कोर्ट यू कैन फाइल योर पिटिशन. ओके, कोर्ट टू हुइच द पिटिशन शैल बी प्रेजेंटेड. ओके, एंड इट इज we are talking about the original civil jurisdiction. The first point we have discussed, where the marriage was solemnized. Okay, the first thing, the marriage where it was solemnized and or the marriage has been terminated. Okay, second point, the respondent at the time of the petition resides. Petitioner matlab, if I am the wife, maybe I am the petitioner. If you are the husband, maybe you are the petitioner. So at the time of the presenting that particular petition, wherever the parties are residing, that is the place to file for the petition. The parties to the marriage last resided together, husband and wife, where they have lastly stayed together or resided together. Then, in ca- in then the in case of the wife is a petitioner, where she is residing on the date of presentation of the petition. पिटिशनर जिस डेट पे प्रेजेंट हो रहा है उसी डेट में वाइफ कहाँ पे है. If the wife is a homemaker, if the wife is staying at the home, then the hometown of the wife where she is staying. If the wife is a working lady, then the working location of the lady जहाँ पे आपका wife रह रही है ना. तो this is the major duty of the court to find out where the person is safe or not. Okay. The last point, the petitioner is residing at home at the time of the presentation of the petition in a case where the respondent is at that time residing outside the territories to which the act extends or has not of being heard of being alive for more than period of the 7 years. Okay, so this is little different. The point number 4, it exactly speaks that, for example, I am a person, I have been disappeared from more than 7 years. 7 साल से मेरा कुछ भी आता पता नहीं है. मैं ना कोई दोस्त से मिल रही हूँ, ना किसी से कॉल पे बात कर रही हूँ, ना किसी के साथ कोई कांटेक्ट है. मैं 7 साल से कहाँ पे हूँ, क्या कर रही हूँ, उसी का किसी भी अंदाजा किसी को नहीं है. राइट. So this is the situation over there when I am totally disappearing from somewhere more than 7 years. Then it is the point to be worried, right? Then the next and the most important point, when the wife is a petitioner, she is residing on date of he is residing at the date of the presentation of the petition. Okay, तो जिस दिन पे पिटिशन प्रेजेंट हो रहा है उसी दिन पे वाइफ कहाँ पे है. तो बेसिकली देखा जाए कि इसी को समरी बता देती हूँ सेक्शन 19 को. आपका ये जो डिवोर्स पिटिशन है ना, वो कहाँ पे फाइल होगी, डिस्ट्रिक्ट कोर्ट पे फाइल होगी. कौन सा डिस्ट्रिक्ट कोर्ट पे, आपका एरिया का डिस्ट्रिक्ट कोर्ट पे. तो व्हाट इज द जुरिस्डिक्शन फॉर दिस, जहाँ पे आप रहते हैं, जहाँ पे आपका हस्बैंड रहते हैं, जहाँ पे हस्बैंड एंड वाइफ मिलके लास्टली एक साथ रह रहे थे. और अगर हस्बैंड कहाँ पे गायब हो गया है, उसका कोई आता पता मिल नहीं रहा है, तो जाने से पहले वो लास्ट कहाँ पे था और उसी का लोकेशन ट्रैक करने का कोशिश करेंगे थ्रू हुज नंबर. ओके. एंड द मोस्ट इंपोर्टेंट पार्ट that at the time of the presentation of the petition where the wife is residing. For example, अगर husband is staying at Delhi, wife is staying at Bangalore. husband का job location है जो Bangalore है, wife का job location Delhi है. तो wife जहाँ पे job करती है at the place of the Delhi, the case can be filed. At the place of the Bangalore, the case can be filed. It is totally the discretion of the parties कि वो केस को कहाँ पे कंटिन्यू करना चाहते हैं. हस्बैंड जहाँ पे रहता है, अगर हस्बैंड ही पिटिशनर है तो अपना लोकेशन पे कर सकता है, वो अपना घर पे या कि वाइफ के ससुराल पे कर सकता है. वो वाइफ क्या कर सकती है, अपना जॉब लोकेशन पे कर सकती है, या पति के साथ वो लास्ट जहां पे रहा था उस लोकेशन पे कर सकती है. कुछ नहीं हुआ तो अपना ससुराल का लोकेशन पे भी केस दे सकती है. नहीं तो अपना माँ बाप का जो घर है वो जहाँ पे रह रही है उस लोकेशन का लोकल कोर्ट पे भी वो केस फाइल कर सकती है. Got it? So these are the situations which speaks about the court upon in which court the petition shall be presented and the petition need to be presented. Okay. Then comes your section 20. It speaks about the contents and verification of the petition, and it exactly means that every petition presented under this act shall state a distinctly as the nature of the case permits the facts on which the claim to be relief is founded, and except in petition under section 11, it shall also state that there is no collusion between the petitioner and other party to the meeting. Okay, got it? Then we are talking about the contents or verifications of the petitions. That means when you are filing a divorce petition, what are the contents of it? What is the process of the verification of the petition? How the petition is being filed? Okay. The second point, it speaks the statements contained in every petition under this act shall be verified by the petitioner or some other competent person in the manner required by law for the verification of claims at may at the time of the hearing be referred to the evidence. Okay. So it is very clear that the content of the petition should be verified properly. Okay. So when the wife is filing a petition, what are the contents of the petition? What are the grounds of the divorce? Why the wife wants the divorce? Those things need to be clear to the court of law that you're almighty. This is the conditions. That is why I want divorce from my husband. So these things need to be made clear to the opponent party itself, and that is explained under section 20. Section 21A speaks about the power to transfer the petitions in certain cases. You may ask me, what is about the transferring power of the petition? That means if I am staying at Delhi, but I am suffering from any kind of the disease and the petition is filed at the place of Bangalore. So I am unable to regularly travel to my husband's location where the petition is filed at the location of the Bangalore. So what I want to do, I want to sort it out over here and I want to transfer the petition to the location of the Delhi. So this is up to me. This is the discretion of the me that how I am going to handle the situation and how I am going to convince the court that this is my circumstances and this is why I want to make my case to transfer to my location Delhi. This is up to me. If I can convince the court that this is my problem and that is why I am unable to travel to Bangalore for this specific cases, in this case, the court may order to transfer the cases to my location. Got it? This is called the section 21A, which speaks about the power to transfer the petition in certain cases. And that we are going to discuss in the next class. Okay. And section 21C, we are also going to discuss about the documentary evidence and the more sections. This is all for today, guys. Wrapping up the class over here. Thank you. Bye-bye.